the tort law, and 67 bill was introduced. It did not become a law. It can be a matter preeminently fit for a positive law, and which can take note of various limitations, immunities, liabilities. For the court to go into and leave them in the abstract could be definitely problematic. And therefore, this narrow context can be set up, dealt with before a division bench in its own ways. So I would very humbly advise the court that these questions frame being too abstract, and the court may not be advised to answer them again in the abstract proposition. For instance, question number 1 itself, to say that one fundamental right can be pitted against another fundamental right, is a well-known proposition constitutional law that there is no hostility between two sets of fundamental rights. They're only balancing of fundamental rights. So this balancing has now been propounded in a different way. I think the court may not like to answer them in the way been propounded by the court. And that's my very humble understanding.
Shall I make a humble submission for the petitioner, Milo? Shall I make a humble submission for the petitioners? Shall I make a humble submission? member of Legislative Assembly makes a speech, but a speech which is not in the strict sense constitutional, to what extent the court can interfere? But last time when it came up, your ladyship was asking, Justice Nagaratnam was asking a pertinent question. How long the court can go into that because of 19(2) limitations? We agree that. We absolutely agree with that proposition. But then, how to balance? Does it mean that a minister or a member of parliament can go on with this kind of disparaging remarks, hate speech, hateful speech? And is it constitutional or is it in tune with the constitutional morality? Whether there are constitutional limitations on their speech? But we suggested two things. One, taking a clue from other jurisdictions, especially from Australia and UK, we suggested a voluntary code of conduct for ministers and public functionaries, number one. Number two, we suggested constitution of a special ombudsman type of device, institution to tackle this.
How can we frame a code of conduct for public functionaries?
The court cannot.
Would we not be transferring our powers under Constitution?
Absolutely.
Encroaching upon the legislative and executive wings.
The lordships are right. We were suggesting a voluntary code of conduct to be formulated by the legislature. This is in that way only. But the question ultimately is, we have suggested or indicated in the relevant paragraphs, in paragraph 50, 51 and 52 of the notes which I am placing before the lordship, about 20 instances where member of parliament, even the prime minister is joked, even the laborers, everybody is mocked at by members of parliament, ministers in the state, even president of India is mocked at by a minister in a state. Now, this is the situation. I have given a data. After 2014, there has been a 450% increase in the number of hate speech, out of which the major portion is shared by public functionaries, ministers and members of parliament. This was never decided.
Kaleshwaran, is there no provision in the IPC, to prosecute in such events,
In fact, your lordships are right. In one judgment, a distinction was drawn between hate speech amounting to offences in the relevant code, including IPC, and there may be hate speech which may not be per se a penal offence, but nevertheless will have an impact on the right to dignity of others. Whether that can be done, even when it is not an offence, whether that kind of speech can be done by a public functionary, a minister, or a member of parliament or legislative assembly is the question. Sometimes your lordships are right. That distinction was drawn in Amit Devagan. Amit Devagan said, two types. Poonawalla also indicated that. Kodungalur Film Society judgment also indicated that. Sometimes it may amount to an offence. The question, what we are proposing is an institution, an ombudsman-like institution, which may reprimand, which may oversee, which may help maintaining a constitutional culture in the public conduct of public functionaries. Now, this is a novel thing which has been placed, and this is the big root cause for reference, which cannot be undone without by simply saying that it is an academic matter.
Whom my learned friend is appearing, but these are all
appearing in 501.
Whom my learned friend is appearing, but these are all
appearing in 501 petition.
We have intellectual curiosity to address all, and we find out what kind of limitations, normative considerations may be involved to ask the court to get. That's why I said to abstract a proposition to say for a statement made by a minister there is vicarious liability for the government. So in different circumstances, so A roadmap has been drawn by the court over a period of time, and they will be applied as and when a situation arises. But to pick up a statement made by a minister as a liability principle for state, I mean, it's going to be a unmanageable proposition. Therefore, it will be in the fitness of thing that the parliament may address it. Government will look into it. So even in US, there's a section 1983 provision which came back in the context of the racial issues and the immunities and privileges matters. So now today, US Supreme Court has a rethinking on whether the concerns on immunities and privileges have been spread very overtly. So then at a later point in time, the court may have to sit back and say, have I drawn it in a abstract way that it becomes unmanageable even for the court to lay down it from principles or to apply it.
See, as far as public functionaries are concerned, irrespective of what 19(2) may say, is there no constitutional culture in our country where there is an inherent limitation or a restriction which is imposed by persons holding responsible posts? It is inherent. There's no need for this court to give a code of conduct on that. Any person holding a public office or as a public servant, there is an unwritten rule and it is part of constitutional culture that we impose a self-restriction when we hold offices of responsibility and not blabber things which are, very disparaging or insulting to our other countrymen. There is something like a constitutional, restriction or limitation inherent in such persons. So this must be inculcated in our political society and our civic life.
Exactly. We agree that. That is why we never said that this court will have to formulate a guideline. We only said there is a requirement to indicate the need for a voluntary code of conduct. But it is high time, Lords may please to see that we have indicated some 25 instances in pages 41 to 40, pages 41 onwards, pages 41 to 45. 25 instances. They are all ministers or members of parliament. When they do that,
when the judges are comparing, is it not appropriate that there's some silence from the other side?
Free speech is restricted.
the Lordship,
Abuse of free speech.
free speech. Free speech and
Abuse
hate
of free speech.
Free speech and hate speech are taken together. Often free speech is taken as a right to hate speech.
Yes,
That
please
is
give
the
us
unfortunate part of it. If
please
your
give us
lordship,
please give us 1 or 2 minutes.
yes, I'm sorry.
If you permit, we'll continue.
Extremely sorry about it.
Attorney General.
We'll ask him, the big question is into judge.
Attorney. What have you got? What you are suggesting is it is for the parliament because there is already a provision in the IPC.
Yes.
If they want to add something more to it, maybe to bring within its fold, it is for the parliament to.
That's
This
right.
is what you are suggesting.
That's right. In fact, of course, assisting the court is not a problem. But to assist for what purposes and ends, ultimately we spend a couple of days' time and we reach the same conclusion. I prepare a small note, you'll also just look into it, and then if possible, on the basis of this note, the matter can be closed.
Awesome. And also,
And this note does not go into in extenso all those issues, but only for the purpose of answering these issues.
and also give us those two judgments also, we will have it.
Yeah, that's right. These are two judgments. One is 2018, 9 SCC
Yes,
501.
yes.
The next one is 2021, 1 SCC 1. And in both matters, there are detailed guidelines and then principles stated, which will be sufficient enough to deal with this.
Mr. Kaleshwaran, do you have this?
I couldn't
Yes, I
share
have.
it.
Copy of this?
No, I couldn't share it with him. Let me.
I
But
don't
didn't
have
know-
that
I didn't
judgment.
know it was
but
appearing.
I have prepared a written submission which contains not indication with respect to both these judgments, where the relevant paragraphs have even been quoted. And after that, I said that there are instances which may not attract the penal provisions made by the parliament. Therefore, there is a dearth. There is a vacuum. That is the condition. Your Lordship may permit me also. My colleague is there, Ms. Radha Lakshmi is there. I am sorry that I am not physically before your Lordship on account of certain medical constraints. My learned friend will hand over that written submission to your Lordship, which is a 57-page note, which takes in both this Poonawalla judgment as well as Amish Devgan judgment, and which says, in fact, that this is not enough to tackle this issue. The problem is precisely this. In many of the instances, 90% of the cases, but the respondent is rather the parliamentarians. The lawmakers make this. The ministers make this. Therefore, should we again leave it to the legislature, or whether the existing law, at least with respect to Human Rights Commission, your Lordships are aware, I have suggested invocation of Section 2 of the Human Rights Act, invocation of Section 12 of the Human Rights Act, but the Human Rights Commissions are not so far activated in this regard. Your Lordship may kindly
Right.
appreciate
What we suggest is, Mr. Kaleshwaran, let us hear Mr. Attorney General, and thereafter you can make your submission. Let us see how things.
One concern, when you try to place the judgments for the purpose of inviting the attention of the court, it is not that there will always be a residue which is left out in some judgment or the other. You don't pick up that residue and say, now I lay some further proposition again. My only concern is it will be in the abstract again. To ask the parliament or a government to say, all right, there's a code of conduct required. All this, the very fact that the court has framed these questions and the government's attention was drawn to it, and the fact has been in the public domain, itself is a sufficient attention paid by the government. For the court to go into it and say, we want you to have a particular institution, that must be a matter of parliamentary concern. Yes. Your Lordship will keep the issues framed alongside my notes so that these are the issues framed by the court on 24th of October 2019. answers.
This is dated 24/10/2019, right?
That's right. So the first question are the grounds specified in Article 19(2) in relation to which reasonable restrictions on the right to free speech can be imposed by law exhaustive, or can restrictions on the right to free speech be imposed on grounds not found in Article 19(2) by invoking other fundamental rights? My answer to that is, as a matter of constitutional principle, any addition, alteration, or change in the norms or a criteria for imposition of restriction on any fundamental right has to come through a legislative process. It can be stated that the restrictions that have been enumerated, for instance, in Article 19(2) to 19(6), have to be taken to be exhaustive. Given the position that such restrictions have to be taken to be exhaustive, the court may not invoke any other fundamental right, namely Article 21, for imposition of restrictions not found in Article 19(2). It's also a principle of constitutional law that there can be no conflict or collision between different fundamental rights of freedom. As such, one fundamental right cannot be pitted against another fundamental right. Balancing fundamental rights, either to avoid overlapping or to ensure mutual enjoyment, is different from treating one right as a restriction or another right. Then, question number 2. Can a fundamental right in Article 19 or 21 of the Constitution of India be claimed other than against the state or its instrumentalities? Answer. The Constitution itself sets out a scheme of claims of fundamental rights against the state or instrumentalities, and is also enacted in respect of breaches or violations of fundamental rights by persons other than state or its instrumentalities. Any proposition to add or insert subjects or matters in respect of which claims been made against persons other than the state would amount to constitutional change. The changes may not be suggested or propounded as matters of interpretation. The concept of state action is propounded and applied in US constitutional law, and the enactment of so and so are to be seen in the context of peculiar state of affairs dealing with governmental and official immunities from legal proceedings. In view of specific provisions of the Indian Constitution, the Articles 15(2), 17, 23, and 24, there may not be strict need to take recourse to law obtaining in the USA. However, the concerns that have also been voiced in regard to unqualified liability principle also deserve to be kept in view. Consequently, claims against persons other than state, either through enacted law or otherwise, must be confined to constitutionally enacted subjects or matters. It is submitted that enlargement of such constitutional principles will also have the consequence of opening a floodgate of constitutional litigation. The principle of where there is a right or the remedy must also be a matter of positive law. Then issue number 3, whether the state is under a duty to affirmatively.
Mr. Attorney General.
I'm sorry.
There may be no right against the state when a
Yes.
particular individual makes a statement. But on account of that public functionary making a statement, if a section of the population or an individual is affected, there is always a civil remedy available. So it cannot be said that there is no remedy.
With regard to answer to question number 2,
No.
there is always a remedy available.
For instance, we have the SC/SC legislation.
Apart
Right.
from that,
Then the bonded labor legislation. Legislations take care of all these private actors' violations.
Under defamation, a civil tort. So it is not that there is no remedy at all. There is a civil remedy also may be availed by a person who claims that he or she I am on civil remedy.
When
No.
the
Always available. It is not against, it may not be against the state, but it may be against the particular person making the statement.
No, for instance, we have a principle of defamation.
Yes.
That's right. Therefore, there are disparate principles available in various legislations here and there. Maybe there is a need for a codification. That's a different issue. But today the court is not called upon to answer the question of a codification of all these disparate principles and put them in one place. And I don't think whether that exercise would also be worthwhile doing in the context of this case.
But under the existing legal regime, a remedy could always be thought of by an individual if he or she is hurt
Right.
by a particular speech.
That's right.
Attorney, in any case, can we do it? It's exclusively within the domain of the parliament. That's what primarily I feel.
My reflection was were we not setting some very obvious things while framing this question? That's something very obvious.
You can go to the court individually.
Concerned about again question number 4. Can a statement made by a minister traceable to any affairs of a state or for protecting the government be attributed vicariously to government itself? Especially in view of the principle of collective responsibility. Too many ideas have been jumbled up here. Now, the collective responsibility is an entirely different governmental concept.
Attorney, it is like saying the statement made by a judge is attributable to the court.
Exactly.
So I was worried with Mr. Kaleshwaram Raj said, public functionaries, whether it includes us also. And whether the speech would include irresponsible statements also.
Fortunately, there was no instance
There have
of
been
that
some
kind of
thoughts on
thought.
institutional responsibility.
I will wait to the learned attorney, not to you.
Well, let me have my answer to that. Issue number 4. Answer to issue number 4.
Going further, suppose if
Or three.
some wrong judgment is given by one bench, can it be attributed to the entire Supreme Court?
Certainly not. Certainly not.
You have missed
And then
3, Mr. Attorney. You have missed question number 3. You have missed.
That is what you are saying.
No, you answer question 4.
Question for me.
3.
yes, answer to issue number 3. I'll read that and then come to issue number 4. There are sufficient constitutional and legal remedies available for a citizen whose liberty is threatened by any person. Beyond the constitutional and legal remedy and protection available, there may not be any other additional duty to affirmatively protect under Article 20 or the right of 21 citizen. Case of infringement of fundamental rights are taken care of under Articles 32 and 226. It will always be a matter of fact whether there is an infringement at all. Then answer to question number 4. Conduct a public servant like a minister if it is traceable to discharge of a public duty or duties of office or subject to scrutiny of the law. Sanction for prosecution can be granted if misconduct is committed under color of office. Such misconduct, including statements that may be made by a minister, cannot be linked to the principles of collective responsibility. The concept of vicarious liability is incapable of being applied to such situations, and no government can ever be vicariously liable for malfeasance or misconduct of minister not traceable to statutory duty or statutory violation for the purpose of legal remedies. Ministerial misdemeanors which have nothing to do with discharge of public duty and not traceable to the affairs of the state will have to be treated as acts of individual violation in individual wrongs. To extend in the abstract the liability of the state such situations or instances without necessary limitations can be problematic. That's where I'm voicing my concern. And we can't foresee what kind of limitation is necessary at this point of time. And that's why even in the kind of compensation from Rudul Shah onwards, the pendulum has swung from one quantum to another quantum. So therefore, it may be a need for a legislative intervention, but that does not mean that the institutional proposition being proposed will have to be seized in this case.
Yes.
In view of my answer to the other questions, I don't think question number 5 even need to be gone into. Nilabadi Bera has said about constitutional thought. Is already there a proposition of law. I don't think that another chapter to be added to that.
It covers all your submissions. Unless you want to point out something from Poonawalla.
I don't think I need to travel any further on this.
Unless you want to point out something from Poonawalla and other than.
Secrecy.
You want specifically to point out something from Poonawalla.
No, I don't think, because then that will take the court into a long journey again into all these questions.
What you are saying is it requires a legislative interference, that's all. This is the sum and substance.
That's right. Because the issues are now before the court will look into them and say yes, it may be preeminently a fit subject for a codification. Look into it.
There is already a legislation in IPC. If any addition is required, it is for the legislature. This is what
That's
you are
right.
suggesting.
Whether it's an addition to IPC or a need for a complete codification, etc., all that will be matters of parliamentary debate. But I see even across the globe, these issues have come before different apex courts. But for the courts to lay down final binding principles of liability on government for individual misconduct will be a very serious issue.
Question is whether there is any.
When the parliament applies its mind, it can say yes, there are the following limitations, and there is a debate, and then it will be tested in the court. But before that, we want.
See, the reason why there is no legislation all this while, is there has always been a self-imposed
I'm sorry.
restriction.
I'm sorry.
The Attorney General. The reason why there has been no legislation all this while is because there has always been an inherent, self-imposed restrictions by persons holding responsible positions in public life. Now, the impression being given is that those kind of restrictions are being slowly relaxed. As a result, persons are speaking in such a way which is offending other persons, and nobody is checking it. That seems to be the thrust of this whole.
Exactly. I mean,
Rather than going into the nitty-gritty of Article 19.1a, 19.2, etc.
The concern is well taken. I am not.
The concern is this. See, nobody seems to be checking them. And anybody can get away with saying something which is disparaging against somebody else. Especially persons holding high offices, public functionaries, public servants, what you may say. This is the object of this case, and going into whether.
The reason why these cases come before court, all that the concerns are well taken. I am not even disputing for a minute. As the highest officer of the state, I don't think that these are to be simply wished away. No. But then how do we really address those questions? That's the most important aspect of the matter. Do we address these questions through a debate in the court, and then how far we can foresee all those limitations and the inherent intrinsic difficulties may arise when the court is called upon later to apply its own law. So therefore, in my understanding, it's better that there is a parliamentary debate on this question and Parliament can look into it. And maybe there is a need for a law. I'm not even,
Yes.
maybe there is a need for a law. But then
Need for a law.
we look at the larger percentage of responsible persons in public offices who know what to speak and what not to speak. We are only picking up those people who have probably aberrations which happen.
Explain.
So the aberrations must be taken care of. That's about all. Can be different. For instance, the remedies which are ordinarily available to an ordinary against an ordinary citizen and a public functionary, if there is a excessive protection to public functionary, one can understand. But there is no such excessive protection. We have a section 197 CRPC also very strictly read. So it must be the discharge of public duties. If not, then you face the music of the law. That's why even in Tehsil Pulawala in para 40.1,
Covers everything.
very well.
Yes. Alexandra, you
Yes,
make
madam. I just wanted to make 2-3 submissions only, madam. Based on my written submission, which Lord is by this time placed before your lordship.
Yes, we have.
Now, 3 broad submission which I will make. But it is not as if Lord, I am opposing the center's stand as such. But we also do not say for a moment that this court will be imposing additional restrictions on free speech, even the free speech of the public functionaries. We don't say that. We only say that when they are public functionaries, well, as your ladyship was indicating, there is an added responsibility in them to maintain the constitutional culture in their public conduct in public domain. This is to be addressed. That is number one. We don't say that additional judicial restrictions can be imposed on free speech even of public functionaries. We don't say that. Article 19.2 or 19.1 as it stands, but unlike 25 or other articles, does not permit it even. We concede that. Secondly, we say that there, even if free speech is as such applicable to public functionaries, subject to other constitutional limitations, nevertheless, but hate speech has to be distinguished from free speech. This is my second broad argument. Hate speech, when made by a divisive speech, when made by a minister of the state or center, but even during communal rights, certain times it may not be amounting to an offense, but some public check will have to be there, even when it does not amount to an offense. This is my second broad proposition. I have given certain instances and suggested but to 2 methods predominantly. That is the third submission. The 2 methods are, but it is unless and until the legislature or the government is motivated to do that, but they may not even think of promulgating a voluntary code of conduct. So far, it has not happened, and this remains unchecked for almost a decade. For the last decade, any minister, any MP, any MLA can say anything, irrespective of the consequences is the situation. This is something unprecedented. I have given the data also in my written submission. And lastly, what I have suggested, even when it does not amount to an offense, even when a poor victim, a lady or a laborer or a minority community person may not be inclined or facilitated to set the law in motion, but there has to be a mechanism in a country like India where I have suggested ombudsman with his history.
No. Can we do that, or is it for the parliament to set up a mechanism? Or
your lordships are right, my lord. I agree that your lordship may have to clarify the gravity of the situation and suggest it.
Very many things, my lord, and even now, your lordship may please to see the human rights commissions are rather deactivated. That is a prime concern. State human rights commissions are there.
Yes.
Mirror, state human rights commissions are there. The National Human Rights Commission is there. Even mirror, at the time till, I am not even saying that a judicial legislation is required. I don't say that. I am only saying that unless and until, hopefully let us hope, let us have an optimism that the Parliament will promulgate a law in future, if at all. Till then, I am not that optimistic, at any rate, for the sake of argument, I am saying. Till then, we'll go invoking Section 2D of the Human Rights Act, the Protection of Human Rights Act. But there are State Human Rights Commission and National Human Rights Commission. The definition of human rights involve a right to dignity. Human rights as defined under Section 2D will necessarily include a right to maintain dignity against hate speech as well. That is how one can read Section 2D of the Protection of Human Rights Act 1993. Human right means the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. But this is how human rights are defined under the Act. And the commissions under Section 12 are empowered to take cognizance either on complaint or even suo moto, which never happens at least in one among the 25 instances which we have indicated in the written submission. Not even single instance is there where the Human Rights Commission has acted. But this is therefore an issue which may require some deliberation. Otherwise, it will again, if it is left to the Parliament or lawmakers. But when this is the situation when lawmakers themselves do it sometimes, unfortunately, but can this court be taken as absolutely helpless in this regard is the question. I am only seeking a middle path. I am not saying there will have to be some kind of reconciliation. But Nelson Mandela famously said, for to be free is not merely to cast off one's chains, but to live in a way that respects and enhances the freedom of others. But I think, and I submit, that this would apply to the public functionaries as well. I am not seeking any curtailment. We all staff, the 19.2 is broad enough already, as your ladyship was indicating the other day. But we cannot impose further restrictions. The Lordship will not be doing that also. I perfectly understand that. I agree. I respectfully agree with that view. I support that view. But I am only saying, but something which is not penal, some institution which is empowered to reprimand, to give a close watch on it, but that is required. That is a constitutional requirement in these tough times. If your lordships are agreeing to deliberate on this, but I can supplement the further materials. How? But there can be voluntary code of conduct, not something which is, your lordship can always suggest that. Your lordship may not be imposing that. I can give certain good models from other jurisdictions. Secondly, but a special ombudsman for this, which may not be punishing persons for what they talk, but which can always reprimand the public functionaries, which will put certain fine guardrails against the public functionaries. That is an imperative, but in our constitutional climate, as it now stands, this is my submission. I
All right,
place
all
my
right.
written submission before you.
All right. Yes, amicus wants to say
Yes.
something.
Yes, Your Lordship. My submission is that first, of course, I indicated, Lordships, these issues can be gone into in a regular bench because most of these issues which have been raised have already been decided by this court. Now, the concern raised by Justice Nagaratna. Now, we have a public law remedy for violation of fundamental right, and that is constitutional tort laid down in Neelabati Bahera. So let us take an example. If by a statement made by a minister in his official capacity, it violates the fundamental right of the citizen, this court, under the law laid down by Neelabati Bahera, common cause, will act against the minister in its public law remedy.
But the contention appears to be, we don't have sufficient statutory provisions as of now.
Yes, Your Lordship.
What do you say for
Your
that?
Lordships, as far as the ministers are concerned, there is a code of conduct. But your lordships have also held that code of conduct is not enforceable in the court of law. It is for guidance. It is in Jayalalitha, that's what your lordships have held. So at the most, my submission is that we are talking about free speech of a minister. Now, if the question of collective responsibility doesn't arise, if the minister in his official capacity, let's suppose he tries to make a statement which interferes with investigation. Now, that's clear violation of fundamental right, and that would be covered by constitutional tort. In fact, your lordships, in the case of state of Maharashtra, where a chief minister had actually interfered with investigation, had made the chief minister party before this honorable court and imposed costs on the state, because the minister is the functionary of the state. So that is how your lordships have dealt with individual situations. But when the court is asked to lay down general guidelines, now lordships, the problem there is one stray observation of the court can affect many of the rights under 19(1). That is my apprehension. Now, it is not my case that the petitioner does not have a remedy. If the petitioner proves that his statement, the statement of the minister, has violated his fundamental right, then the law is already settled in Neelavati Behera. And in fact, in common cause, it was argued that this court can invoke constitutional tort only in Article 21 cases, and that has been specifically negatived by the court. So there are other fundamental, and as far as actors, non-state actors are concerned, lordships, that issue doesn't arise here because we are talking about the statement of a minister.
The repetition. But I was given the liberty to get myself included in the repetition. So far as the first question is concerned, it has been referred for consideration. I have a submission to make. Wherein Lord was asking, can we at all, if there are remedies available, can we at all
Consider the question over and above 19. That is one of the questions which has been, which is included in question number 1.
and the notes, the suggestive questions which has also been submitted by the amicus. So if your lordships come to 19(1)(a), there can be two ways of looking at the speech being made by the public official. One is, my lord, he makes his speech or the statement or expression, whatever it is, in his capacity as the public official, for which he will never have the protection under 19(1)(a). So far as he is making a speech, even after being a public official, he can make a speech as a citizen alone. He will get the protection under 19(1)(a) only if makes a speech or expression as the citizen. Therefore, my lord, what happens is this first question, so far as please come to 19(1)(a). The lordship is taking 19(1)(a).
My learned friend is appearing for the interview.
Yes. Let him assist. Let him assist.
Begins with this, my lord. This is a positive right given to all citizens. All citizens shall have the right to freedom of speech and expression. Now, any person making a speech will get this, but it will be eclipsed. Why not? The restriction is contained under 19(2). Whatever is reasonable will be contained under 19(2). But the moment he steps into the shoes of the public official and makes a statement, 19(1)(a) is gone away.
So he is to be a citizen of India.
No.
He happens to be the citizen of India. He will not take himself away from the citizen of India. But then he will not get the privilege of 19(1)(a).
Why?
That is what?
Why?
Well, my
Nobody says that.
This is akin to.
rewriting the constitution.
May just make the submission good, my lord. Please hear me after this question. I am a little sticky pitch. I understand. This is the prescription which should come. He still happens to be citizen.
So your contention is to be accepted.
Yes.
19(1)(a)
Yes.
would exclude the public officials from the protection.
Therefore,
So they will not be citizens. They will not be citizens for the meaning of 19(1)(a).
provided he steps in the shoes of the public official. Why I say, well, the same rights are available under First Amendment to the US Constitution. The First Amendment was interpreted to say that the moment you exercise the right as a public official, you will not get the
Protection under the First Amendment. 19(1)(a) is similar. Therefore, my lord, envisage a situation minister is acting as as in the cabinet. He makes a statement, comes out, makes a statement or gives a speech as a minister. Now you will take it as the minister's speech. He will not get the protection under any one. He is also having the immunity. Say for example, Article 104. So whatever happens in the Legislative Assembly, he gets a protection. He gets an immunity. This court has held that those which are available under 104 is not guided by 1918. The restrictions cannot be 19.2 as well. The restrictions are those which are contained under the rules of the Legislative Assembly. Therefore, my lord, the moment a person, whoever it is, if he is holding a high post, even for my lord, at times there are wayward situations in which the judges come to the court and has argued some cases as well. He will not get the protection of a judge. He will not get the protection of a citizen under 1918. He cannot be taken to be one of making a speech under 1918. You will not get the protection at all because you have put yourself in the shoes of the public official. That is why, my lord, my submission would be, therefore this question becomes important and that has been submitted by this has never been considered at all. Because once you step into the shoes of the public official, are you entitled for the protection under 1918 needs to be decided. That has been referred to in the question. First question concerns that as well. Therefore, the first question also says whether over and above what is contained under 19.2, the reasonable restrictions, can there be more restrictions? So far as a person who is a public official, my lord, though part 4A does not say, my submission to this is what brought from my lords as well as Justice Nagaratna as well. The constitutional principles are there and there are fundamental duties as well. Now for a person who becomes a public official, rather than what is contained under 19.2, you will have to necessarily abide by part 4A. Part 4A 15.1A2, my lord may have a look at 51A 4. Sorry, E. Therefore, over and above 19.2 is the power of the state to enact a law. Now, he is even without a law, he is bound by this and also by the oath. Also by the oath, you will abide by the constitution and constitutional principle. Please come at 51E, capital E, A capital, 51 capital A E. To promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities to promote practices directly to the dignity of woman. In my case, this is what has happened, but let us, notwithstanding what has been stated by the minister, my lord, 19.2 alone should not be the relevant factor for a person to be guided as to what his rights would be under 19.1. There are judgments, if your lordship is going to this question, my lord, there are judgments. Therefore, today, my lords may have to necessarily decide. And when there is clear, now we are not alone, my lord, concerned with the speech being made in an assembly. We are all the more concerned with the statements a person makes in the social media or in Twitter or Facebook, whatever it is. The public officials comes out, make the statement, the reach is huge up. The responsibility or rather the presumption is that he has access to the information and the information is being disseminated. Now, therefore, what happens is, unless otherwise there is a higher pedestal than 19.2, which is what is to be decided by lords, whether at all a public officer acting in his capacity as a public officer has the rights contained under 19.1. It is only, I can, my lord, it can necessarily, I will be, my lord, in the event of, my lord, disseminating a public opinion, generating a public opinion, act as a citizen, make this a speech, uses the technology, uses the social media or whatever is there to disseminate information or to exercise my right to speak. But the moment I use it as the public office, there may be, my lord, the misconduct taken as against me. But that alone would not be sufficient because you are also bound by the constitution and the principles contained in the constitution which is being violated. What happens thereafter is that he gets
understood your submission.
Yes, what I do is.
You give your written notes, you consider that.
That would be better. That I'll restrain my speech.
All right.
You will be entitled.
That's all? Yes, solicitor, you want to say something?
Lord, I would not waste your lordship's time, my lord. I'll say, my lord. So on the same lines, I'll give my, my lord, written submissions, my lord.
Yes, attorney, you want, yes.
Only one last word.
Yes.
For public servant, there are rules of conduct. If you breach the rules of conduct, then you will face the consequence. So we are talking about whether the court will lay down this kind of rules of conduct in a very important dimension of free speech. And therefore, a higher pedestal than Article 19.2, virtually asking the court to introduce into 19.2 something which the Parliament has not put in. It's fascinating to say a higher pedestal. Of course, the nation may need all kinds of limitations on conduct of public servants. But do we have, in the context of this particular case,
The first amendment itself was necessitated because of certain.
That's right.
Shall I just point out one
I
thing?
very humbly advise that the court may not go into these questions and answer them beyond whatever is necessary for answering them as indicated.
Yes, Kalecharam, yes.
Yeah, just one submission, my lord. I am also agreeing, my lord, broadly that, my lord, the questions are slightly problematic. My lord, I do concede that. Whether these questions should be retained as such and answered as such, my lord, is something which your lordship may decide. My lord, I don't say that the questions are very novel, but I nevertheless maintain that the issue is novel. Therefore, what I would request, my lord, I am also giving a compilation along with my written statement, my lord, which is my lord, a large one, a big one. Your lordship may consider these suggestions, my lord, in the context of public functionaries in particular. I have given the suggestions, I have given the entire material by compilation.
We will consider. Yes, Amicus, you want to add?
Lordships, I don't want to waste your lordships. I have already given my written note, written submissions.
All right, thank you very much. Reserved.
Grateful.
Obliged.
Grateful.
There's also a compilation which I can hand over to the courtmaster.
Yes.
This is your volume. Yes.
Ram.
Yes. Lord, here the question is.
Just 1 second.
May I state the question?
Only a minute. As is for the petitioner, but I have to say something at the outset, my lord, so that if can be considered at the outset.
Yes.
Lord, the question is this. Question is interpretation of Article 105. Article 105, sub-article 2, which provides for an immunity to the members of parliament, and my lord, corresponding article is there for members of the legislative assembly, which is called, my lord, privilege or immunity from prosecution. My lord, that arises in terms of, my lord, two instances: A, voting; B, something which is spoken inside the house of the parliament. Your lordships are aware, in our parliamentary democracy, the whatever happens within the house is supreme. Outsiders are not permitted to interfere. Lord, the question, my lord, I am not going into the facts of the case, but only for the purpose of what is relevant for me to point out at the outset. This is a case where the petitioner is alleged to have taken money for the purpose of voting in a particular manner inside the house. She did not vote as per the desired wish of the person paying the money. That's the allegation. The question arose whether she is protected by the immunity or not. The court answered the question in a particular way, which right now your lordships may not go into. The CBI raised the contention that she is not protected. They raised the contention that she is protected, etc. When the matter was being argued before the regular bench, when I say regular bench, it means other than the constitutional bench, the judgment in case of P.V. Narasimha Rao was cited.
Yes.
And cited by them. Just P.V. Narasimha Rao judgment, which is a constitution bench judgment, the similar question arose: what is the extent of immunity of members of parliament and legislative assembly? Here it was a member of parliament question. Out of 5 learned judges, there were 2 questions before the constitution bench. A, whether the members of parliament and members of legislative assembly are public servants or not. And second, whether they are immune so far as the question of voting and question of their speaking something within the house is concerned. Lord, out of 5 learned judges, 3 learned judges, my Lord, namely Justice S.C. Agarwal and Justice Anand, who were in minority, held that though they are not protected. Third learned judge, Justice G.N. Ray, my Lord, differed and said that no, they are protected, though he concurred on the question of public servant, with which we are not concerned here in the present case. And 2 learned judges, my Lord, Justice Bharucha and Justice Rajendra Babu, gave a detailed judgment saying that no, the protection still continues. Even in case of a criminal offence, the protection continues, and they have given reasons, they have, my Lord, examined the case law, etc. So now this judgment is a constitution bench judgment where 3 is majority and 2 is in minority. Now your lordships may, my Lord, kindly see the reference order.
That I think I should be permitted to place.
All right, we will hear you.
I'm a petitioner, I think I should. As an officer of the court, I'm equally bound, as the petitioner.
I'm saying something,
Ramachandran.
I'm not saying something against you. I'm not saying something against you.
We will hear you.
It's a question of law, therefore I'm nothing against you. I didn't mention the allegations also in detail. Because this is not the forum where we go into the facts. These are all broad propositions. Kindly come to the order of reference, my Lord, at para 4. The precise question was dealt with by a 5-judge bench of this court in P.V. Narasimha Rao versus State, while 2 judges on the bench took the view that protection under Article 1052 and 194 to 194 is for the Assembly of the Constitution of India, and the immunity granted cannot extend to the cases where bribery was for making a speech or vote in a particular manner in the House is alleged. The majority view, while acutely conscious of the seriousness of the offence, felt that the wrongful act of the sense of indignation of the bench should not lead to a narrow construction of the constitutional provisions which may have the effect of impairing the guarantee to effective parliamentary participation and debate, something which my learned friend would be arguing. And I'm in principle, as a constitutional proposition, supporting him. Therefore, I'm saying, my Lord, I'm not arguing anything against him. Having considered the matter, we are of the view that having regard to the wide ramification of the question that has arisen, the doubts raised and the issue being matter of substantial public importance, we should be requesting for a reference of the matter to a larger bench, as may be considered appropriate, to hear and decide the issue arising. We order accordingly, and the matter was placed before my Lord the Chief Justice on administrative side. Now the question is, it is P.V. Narasimha Rao judgment which is placed for your Lordship's consideration.
Mr. Tushar Mehta, therefore, supposing if we accept the majority view of in P.V. Narasimha Rao, probably this matter has to be closed.
That's right.
Supposing if you don't agree, it may have to go to a larger bench.
Exactly, that's all I am saying at the outset. That before we invest your Lordship's time further, if your Lordships will not agree that the majority view is correct, which according to me is correct, On the facts, my lord, we will argue before the regular bench, my lord, whether protection is there, not there.
That is on facts.
That is on facts. But on the proposition, my lord, the view expressed by my lord Justice Bharucha and concurred by two honorable judges is so convincing that it would be difficult, my lord, for any one of us to argue that this protection can be diluted because some facts are so.
Mr. Ramchandran will have to cross that hurdle.
Pardon?
Yes.
No, my lord, he is also saying the same thing. But
I haven't said anything.
Lord, for the purpose of, Lord, we are before
the
the institution bench,
reference
we don't use such, my lord, childish humor. My lord. This is his case. My lord. This is his case. Sir, this is his case.
It appears that he must have argued the correctness of PV Narasimha, and therefore the three judges bench found it necessary to refer it to a
No, my lord, he relied upon PV Narasimha. He relied upon PV Narasimha.
So that we will have to ask him whether if he concurs with PV Narasimha, then there is no question of this being answered.
Answered, my lord. Then
Only in the event he is in a position to convince us that the constitution bench in PV Narasimha does not lay down a correct proposition.
my lord, if he argues, then he loses. My lord. Then, therefore, he argued that this covers my case. His argument before the three-judge bench was that I am covered and fully protected by the judgment in PV Narasimha.
But who is opposing him then?
On merits, I am opposing him.
Not on merits, on this.
On proposition, I don't think, my lord, anybody.
But the court has said, see in paragraph 5.
That was God's view. That was God's view.
Doubts arise.
Regarding
Yes.
That's what I am going to submit, my lords.
Just 1 second, Ramchandra, Raju, 1 second. Right or wrong? Tell us now.
First of all, my lords, let me clarify.
Yes.
I was not intending to be frivolous at all when I said I have not said anything. When I said that, it was in the context of the doubt.
Nobody said that you are intending to be.
No, my learned friend said childish humor to that extent.
Humor, it was on the lighter side, I said. Don't. It's a serious.
What I said was in the context anticipating the doubt which Justice Gawai expressed a little later. It is this, who raised the doubt in that context. Now, kindly, therefore, see the prior order first of 2 learned judges sending it to 3 learned judges. That's a prior order. That is, my lords, 23/9/2014.
Yes, we have.
Lordship, please. Pleadings are complete. Short order. Justice Nagaratna has got 23. All my other lordships have got.
Page
23/9/2014.
Page 7.
Pleadings are complete.
Pleadings are complete. Since the issue arises for consideration of substantial and of general public importance.
Next one.
23
Since
Page 6 or 7.
7. Page 7.
Since the issue arises for consideration, is substantial and of general public importance, we refer these matters to a larger bench of 3 honorable judges to be constituted by the Honorable Chief Justice of India. Petitioner shall be free to press his application for ad interim stay before the larger bench. So as far as this is concerned, it's a mere reference to 3 learned judges. because of the importance of the matter. No doubt expressed about Narasimha Rao. Then, my lords, we may come to the order which my learned friend, the Solicitor General, has already read out, but I want to read it from my point of view. This is a detailed order, and then there's a court proceeding also. Leave granted. Para 2. The criminal prosecution launched against the appellant is sought to be nullified on a claim of immunity under Article 194(2) of the Constitution of India. The gravamen of the charge against the appellant is that he had accepted a bribe to vote in favor of a particular candidate in the Rajya Sabha election that was held sometime in 2012 in Jharkhand. The precise question was dealt with by a 5-judge bench of this court in P.V. Narasimha Rao, while 2 judges on the bench took the view that the protection under Article 105(2)/194(2), because these are pari materia provisions for the state legislature of the Constitution, and the immunity granted cannot extend to cases where bribery for making a speech or vote in a particular manner in the House is alleged. The majority view, while acutely conscious of the seriousness of the offence, felt that the wrongful act and the sense of indignation of the bench should not lead to a narrow construction of the constitutional provisions, which may have the effect of impairing the guarantee to effective parliamentary participation and debate. Now, my lords, this is crucial, para 5. Having considered the matter, we are of the view that having regard to the wide ramification of the question that has arisen, I pause here for a minute, brothers, on wide ramification. Wide ramification was there at the stage of Narasimha Rao in 1998 also. At any time when the question comes up of MLAs or MPs being bribed, the ramifications are wide and public morality is involved. There's no doubt about that. But that is why 5 judges were constituted in 98 to decide this question because of the wide ramification. The doubts raised and the issue being a matter of substantial public importance. So public importance and wide ramifications go together. The doubts raised and the issue being a matter of substantial public importance, we should be requesting for a reference of the matter to a larger bench as may be considered appropriate to hear and decide the issue accordingly. We order accordingly. Now my respectful submission is this. Doubts raised. Where were the doubts raised? It was not the petitioner's case that Narasimha Rao is wrong. Our entire case on merits is that Narasimha Rao was wrongly applied against me by the learned single judge of the Jharkhand High Court who decided the matter. That very case of Narasimha Rao supports me in my claim of immunity.
No,
therefore, I did not say...
What you are suggesting is the minority view has been applied insofar as you are concerned.
No, not even a minority. I'll clarify that. Yes. The minority has not been applied.
Yes.
Now, let me use a colloquial expression. A betrayal vote. What the learned single judge of the High Court says is that instead of the promised vote, for which I am alleged to have taken the bribe,
yes,
to vote for X.
So that means the breach of contract will not protect you from Narasimha Rao. So specific performance is permissible.
Lordship, please. Lordship, please.
Instead of vote, the contract is opposed to public policy.
Lordship, please.
Is it?
Lordship, please. Therefore, that contract being opposed to public policy, the allegation in fact is that I didn't honor that contract and I ultimately voted for my own party's candidate. So instead of X, I betrayed X and voted for Y. Now, the High Court.
Substantial justice is done.
Lordship, please, as far as politically.
No, actually it is a case of cash outside the house and the conscience inside the house.
Lordship, please. Lordship has put it with respect very aptly.
No, but therefore there was no absence of conscience outside the house.
Lordship, please, Bruce.
Or some other contract.
Now let's
Rescinding of first contract and novation of another contract by somebody else. On the lighter side.
now where
And we are not on facts.
Lordship, please. The High Court applies that very Narasimha Rao and equates this betrayal vote, which was not contemplated in the Narasimha Rao case because those facts were not there. In the Narasimha Rao case, there were only two fact situations. That is, people giving the promised vote about 10 or 11 minutes, and one, that is the late Mr. Ajit Singh, who did not vote.
Abstained.
Absent. He conspired. But see, it may be Raju Ramachandran. Why do you say it is a betrayal? It may be a conscience vote.
What is wrong if you say that?
No, conscience vote, but after allegedly having taken, because for the purpose of this argument for the Constitution bench, we have to take the facts as alleged to be correct.
So going by the analogy of the High Court, going by the analogy of the High Court, had you voted in favor of R.K. Agrawal, then you were entitled to win.
Absolutely, absolutely. So that is the anomaly, which is what I am going to argue. The only question involved is the
regular.
application.
That's
right. That is the only question I will be arguing before the bench of either 3 or 2, before whom your lordships may send me back. Faulty reasoning of the High Court, which I will argue they are not here, is in equating the no vote of Ajit Singh by a process of deductive reasoning, which I submit is faulty, to say a betrayal vote is equal to no vote. Our submission is a vote is a vote, and the language of Article 194(2) is in respect of any vote. 194(2) does not talk of which way a vote goes. In respect of a vote, if there is any kind of allegation of any nature, it could be bribery, it could be anything else. Therefore, if I, as the petitioner, have not asked for reconsideration of Narasimha Rao, and I'm only pleading that the High Court has erred in wrongly applying Narasimha Rao against me when Narasimha Rao ought to be applied in my favor. There is no question of questioning the correctness of Narasimha Rao. In which case, if the first order of reference only talked of wide ramifications, and the second order of reference talks of public importance, wide ramifications, and the doubts expressed, who with respect has expressed those doubts? The doubts on paper are only the doubts of the two learned dissenting judges. Powerful reasoning, no doubt. But that is the only doubt on record which could have weighed in the minds of this 3-judge bench. It would have been a different matter if this 3-judge bench had on its own and recorded that paras so and so, so and so, so and so of the majority judgment of Narasimha Rao appear to us to be doubtful in the light of so and so, so and so, and we feel Narasimha Rao may require a fresh look. That would have been sufficient reason. If a seed of doubt is sown in the minds of the bench, either by a party or the bench of its own accord entertains a doubt and articulates the doubt, then it follows, minutes, that the process of reference must be carried further through, as per the judicial discipline, first to 5 judges, and then 5 judges feel, then 5 to 7. But in the absence of such a judicially expressed doubt, in my respectful submission, there is no need for reconsideration of Narasimha Rao.
But Mr. Raju, one question or one doubt, our doubt.
Lordship, please.
Now, the court has expressed doubt on the majority view, right? By 3 judge bench. 1 minute, one by one. Now, neither Tushar Mehta nor you dispute the correctness of the majority view.
Lordship, please.
Now, but the court has raised doubt. Somebody should assist us on the other side also. There is none here.
If you are not for this,
Only a minute.
or sir, just 1 second, let me just complete this. If your lordships as a brilliant opponent read this sentence, and since one of the learned judges on the bench is before this in this bench also, that this itself means the doubts expressed refers to the doubts of the 3-judge bench and not the doubts expressed in the minority in Narasimha Rao, then of course, Milords, the doubts expressed by the 3-judge bench must be adequately addressed.
One more reason, Dr. Ramachandran, actually, this is the case of payment of money. Suppose there is a case members of legislature.
If it is held captive, if the family members,
If it is not protected. But may I say, now if
the fact situation.
you substantially damage.
Mr. Solicitor and Mr. Ramachandran, now in any case, the bench of 3 learned judges, we don't know what was in the mind.
Correct. Well, he is referred.
And also, I want to add, I am also a party to that.
Yes, Lord, if my learned friend allows me, he has substantially diluted his case, my lord. Let me, my lord, further.
And if you allow us.
I'm so sorry. I'm so sorry.
3-judge bench has raised some doubts with regard to correctness of Narasimha. So we have to honor the,
Certain. I bow down. The question would be.
Both of you are one side.
No, we'll assist you.
Both of
On this issue.
On this issue.
Yes, my lord, we'll
Unfortunately, both of you say that Narasimha Rao has been.
No, he tried his best, my lord, to dilute his case. But I still, my lord.
He also doesn't.
But I am saying something slightly different.
Therefore, when a bench of 3 honorable judges.
I bow down. My lord. No further discussion on.
We must have some view of as to whether it is correctly decided or not from an independent.
Lord, let us now, my lord, go a step further. I bow down, my lord. Once there is a reference, it needs to be answered because that's how, my lord, the system works. That's how the discipline works. The question would be, would a bench of coordinate jurisdiction of 5 honorable judges be able to say either way that it does not?
we can say that if we are convinced
that Narasimha Rao has been correctly decided, then we can close the matter. And if we find that it is not correctly decided, then only the question of
reference may.
Lordship, please. Then may I take my notes?
If we also have a doubt, then it has to go to sir.
Yes. That's all.
Now, therefore, now the task.
Ultimately, it is
Lordship, please.
what is the extent of that immunity
Lordship.
for what acts done by a member of parliament or for a member of the legislative assembly.
On the floor of the Kerala Legislative Assembly.
Yes.
By Later, the public prosecutor sought to withdraw that prosecution on the ground of immunity. That withdrawal was not allowed. Not
Sorry.
Yes,
All right,
I'm
Mr.
sorry,
Raju,
I'm answering.
Mr. Raju Ramchandran, please listen to us. See, we want assistance.
Lordship, please.
Yes, yes, we'll assist.
We, Ms. Patwalia, why don't you assist the court here?
Yes.
Please, where is Gaurav Agarwal? He is here. Where is Gaurav?
But Mr. Gaurav Agarwal is really busy as an amicus, and he will not be able
You
to.
assist Patwalia.
Yes,
You please Patwalia.
Surely.
And Patwalia, please assist us, right?
We'll do that.
Because require the other words you have heard, you know.
I've.
Yeah.
Certainly, well, we will also assist him.
Yes, we
That-
need
that's
some
not the
assistance.
question.
If we concur with Narsingh Rao, then further that will not be necessary.
Absolutely, absolutely.
Then send back the matter to the learned 3 judges or 2 judges for deciding it on merits.
Yes.
Correct.
On merits, I am opposing him. No? On proposition of.
We can't go into the question
Yeah,
of merit.
that's on proposition of the constitutional principle, I feel my Lord Narasimha Rao is rightly decided.
That is what Raju says, so no opposition to that.
Raju unfortunately did not say, my Lord, he said many things and we went into a.
No, he categorically
That's not fair.
That doesn't make.
he categorically said that he is protected by Narasimha, but the learned single judge has wrongly applied that.
As a matter of fact, my Lord, as a matter of fact, my Lord, sometimes if we write a novel instead of, my Lord, a para, it is, my Lord, less effective. In a case of Kerala, which he was, my Lord, addressing, in Kerala there were hooliganism in the house, and the court said that they are not protected under 195. That was the one line which was required to be.
Vandalism instead of hooliganism.
Yes, but it was a novel. I am giving a paragraph.
We will do that. Come, right. Come. Say, yes, but the council is requested to assist the court as an amicus curiae. Great, she full name. Gaurav Agarwal. Any initials? No.
No, he writes Gaurav Agarwal.
Only
Gaurav writes Gaurav Agarwal.
he is really Gaurav.
Gaurav Agarwal, learned counsel, learned AOR, right? AOR is requested to assist Mr. Patwalia in this case. List this case when January, right? After 7th.
No, December. I would request for December. I would earnestly request.
Because
for
I was a party.
that doesn't matter. No? How does that matter? How does that?
See, I was telling my brother, just now I told him, so far I am the karta of this bench. I will pass on the kartaship to my brother.
No, my Lord. But my Lord,
All of us would love to have it in December.
we are the co-partners, my Lord.
We don't think that it will take more than a day.
It cannot. It cannot. Should not take, my Lord. If we.
Give a date.
The two perspectives, the judgments and the independent perspective of the amicus.
Today itself, you did not have paper book for that. Strictly speaking, you just have to examine.
It's a question. I have not even opened on fact.
Assist to the
But I think
correctly decided or not.
I'll give a paper book to him, my Lord.
Well, 6th is all right for you?
Any day when your lordship fixes it, so.
6th is Tuesday.
That's all right.
Tuesday is all right.
Lordship, please. Lordship.
List on 6th.
Any vote.
on the lighter side. Your lordships only have the jurisdiction to grant an injunction. But here as a Karta, the co-partners, my lord, injuncted your lordships, my lord, from...
No, but.
Including the co-partners here.
No.
Yes, my lord, but I can't...
Solicitor, who included you as a co-partner here?
My lord, here I
Self.
no, my lord, my lord, I was only on two of us. Would wish, my lord, I can hear, but I...
No, I was just telling my learned brother that I had some objection because by the two of my learned brothers and sisters, they were conferring in some language which we both of do not understand.
Yes, that's an overwhelming majority.
That is, my lord.
All right,
I think, my lord, yes, my lord, the majority can confer in a different language.
All right, we will have it.
Great.
Obliged to Lord.
Karta is recognizing the lady as a co-partner.
Law has Parliament has recognized.
Then now, yes, of course, my lord, your ladyship can be a co-partner.
And Vinita Sharma, again, I am a party.
My lords have decided.
Elder brother is party to Vinita.
Yes, my lord.
We have given a cut-off date, right?
Yes, but I was not including on your lordship, my lord. I was saying we are the co-partners.
Date, please.
Date, sir? Sir, date.
Is regarding interpretation of section 319 of the Code of Criminal Procedure.
Where is Nagamuthu? You are in this case? Not in this case?
319, Nagamuthu,
You assist the court, Nagamuthu, here also. Let him hear. If you want, we can. You can give a date also, but you let us hear, Mr. Patwale. If you want, we can take it up again tomorrow. For you, this is a very small matter, 319.
You had substantially argued it before a division bench. So result is immaterial.
All right. Yes.
May it please you. Lord, my issue is very narrow and limited. And my issue is that the order under 319 in this case was passed after the trial in the main case was over. The order itself records that by a separate judgment, I have concluded, convicted and sentenced the accused today, and then I proceed to pass this order. Now, 319 is a power which is to be exercised during inquiry or trial as per the section itself. This has been interpreted by a 5-judge bench of this court, my lord, in Hardeep Singh's case. And therefore, according to me, it is completely covered. The reference order, I'll read to your lordships, my lord, first, and then I will take your lordships to the facts of this case and my submission.
Patwale, what is the date of the reference order?
Yes, the reference order is dated 10th of May 2019. Yes, that's right. And thereafter it comes to 5 by 5th of September. First 10th May, your lordship.
And then 5th of September. This is by, I think, learned 2 judges.
Correct. And then it went,
thereafter the learned 3 judges reduced to a 5.
yes, and then the learned.
That is 5th of September.
Correct. The learned two honorable judges said that let it be placed before 5.
First division bench.
So the first, this is 10th May, is it? 10th May 2019.
First order, yes, is 10th May 2019.
Yes, we
That's
have.
the order. That is really the mind of the judges.
All right.
Therefore, I'll read that.
Yes, we have.
These criminal appeals are filed against the impugned judgment and order of the High Court.
One minute, my learned.
Just one second.
This one.
Yes. 30? Yeah. All right. Yes, we have.
My lord.
Yes.
These criminal appeals are filed against the impugned judgment and order of the High Court of Punjab and Haryana, dated 7th November 2017, passed in criminal revision number so-and-so and criminal revision number, where the High Court dismissed the criminal revision petitions and upheld the order of the trial court summoning the accused appellants under 319 of the Code of Criminal Procedure. The factual narration of this case is that on 5th March 15, a first information report was lodged in the police station Sadar Jalalabad against 11 accused for the offence committed under sections 21, 24, 25, 27, 28, 29, 30 of the Narcotic Drugs and Psychotropic Substance Act 1985, Section 25A of the Arms Act and Section 66 of the Information Technology Act. Initially under the first charge sheet dated 6 September 15, 10 accused were summoned and put to trial in session case number 289 of 2015. Even though a second charge sheet was filed by the police, the same did not name the accused appellant there. Subsequently, on 31st July 17, the prosecution filed an application under 311 of CRPC for recalling PW 4 and 5, which came to be allowed. On such recall, the aforesaid witnesses named the accused appellant therein. Thereafter, the prosecution filed an application under 319 of CRPC in session case number so-and-so for summoning additional 5 accused, including the present appellant, by placing reliance on statements of PW 4-5 and PW 13. On 31st October 2017, the session court first pronounced the judgment in session case number 289 of 15, convicting the 9 other accused put on trial. On the same day, by a separate order, the session court, while allowing the application of the prosecution, summoned accused appellant under 319 of the CRPC. Agreed by the summoning by the session court, the accused appellant filed separate criminal revision petitions in the High Court of Punjab and Haryana, being criminal revision numbers are given. The High Court, by common judgment, impugned judgment, dismissed the revision and upheld the summoning order. Agreed by the impugned judgment and order of the High Court, accused appellants have approached this court through these petitions. Having heard learned counsel for parties, learned senior counsel appearing on behalf of the accused appellant in SLP number contended by relying on Hardeep Singh versus State of Punjab 14-3 SCC to state that power under 3191 can be exercised at any time after the filing of the charge sheet and before the pronouncement of the judgment. In the present case, the summoning order passed after the order of conviction is in clear breach of the principles laid down in Hardeep Singh Supra. Counsel further contended that when Hardeep Singh has clearly prescribed the stage at which an application under 319 can be entertained, the aforesaid violation is not merely procedural, but rather a substantive one. Lastly, the counsel contended that the moment the trial is concluded and matter is reserved for judgment, then the stage for exercising power under 319 ends and the court becomes functus officio. Mr. Giri Learned counsel, senior counsel appearing on behalf of the accused in the other SLP while generally supporting Mr. Patwalia has submitted that the order summoning the appellant was passed simultaneously with the order of conviction of other accused. The counsel submitted that section 3194 has to be read along with 3191, which provides that the new person has to be tried together with the accused. The principle is based on communality of evidence. But in the present case, allowing such application under 319 goes to the root of the fair trial, as the court has already considered such evidence and proceeded to speak on it. It is the same evidence which would be reappreciated, and the inclusion of which such evidence vitiates the principle of fair trial. Learned senior counsel appearing on behalf of the state in SLP argued that even if it is assumed that the summoning order was passed subsequent to the conviction order, the relevant consideration is that application of mind was within the prescribed time under section 319. The process of application of mind and pronouncement of summoning order are separate under 319, and it is the time of application of mind which is relevant. The court further drew attention to the fact that undisputedly the application under 319 was filed and heard during the pendency of the trial, and the order thereon was reserved. In this context, counsel submitted that application under 319 was separated from the trial by direction of the High Court. That's not factually correct, but anyway, I'm reading it the way it is recorded. In this context, the counsel submitted that application under 319 was separated from the trial by direction of the High Court so as to complete the trial expeditiously in a time-bound manner. Now the aforesaid fact cannot be used to prejudice the case of the state. Lastly, the counsel maintained that summoning order under 319 was passed on the same day, simultaneously, along with the final judgment convicting the other accused. Moreover, there is no procedural irregularity committed. Moreover, he emphasized that the trial in this case could not be said to be completed unless decision was given in respect of all the accused fully. This submission was based on the fact trial had been bifurcated and was pending in respect of the other absconding accused, which would sustain the exercise of power under section 319. Learned senior counsel appearing on behalf of the state in SLP number so-and-so, while supporting the arguments made by learned senior counsel, further submitted that it is settled law that procedural laws must be liberally construed to render justice. Moreover, assuming but not admitted that an irregularity in exercise of power under 319 was committed by the trial court, the same would not vitiate the proceeding. The counsel concluded his arguments by stating that the finding of the trial court cannot be reversed under 456 as the appellant has not made out a case of failure of justice. In the facts and arguments presented, the following question arises. Now, whether the order of the session judge summoning the appellant hearing as additional accused was in breach of 319. If the answer to the above is in the affirmative, would the order of the courts below still be sustained under the code? At the outset, it is pertinent to note that 319 reflects two important objectives. Firstly, the court's duty to bring home the guilt of all accused and render complete justice. And secondly, the duty of the state to take every criminal prosecution to its logical end. This court in a catena of judgments has defined 319 as an enabling provision, especially in the circumstances where the investigating agency has failed to array any person as an accused. This provision empowers the courts for calling such persons to face trial. The section stipulates that a court may summon any additional accused if it appears from the evidence during the course of any inquiry or trial that such an individual, not being an accused, has committed any offence for which such person could be tried together with the named accused. Subsection 4 of section 319 of the CRPC indicates that the proceedings with respect to the summoned individual as per clause 1 of 319 may be a de novo or joint trial. The appellants have argued for a comprehensive reading of 319(1), where the aspect of application of mind by the judge as well as pronouncement of the order are both bound by the prescribed time limit. They have extensively relied on Hardeep Singh to point out that trial court was functus officio and did not have the jurisdiction to deliver the order of summon. The High Court, while repelling the contention of the appellant that the trial court was functus officio when the summoning order was passed, placed reliance on the factual matrix explained later in Shashikant Singh and noted that the decision in Shashikant was on the same point rather than Hardeep Singh. In Shashikant, this court was concerned with a unique situation. The question which was before the court therein was, can a person summoned in pursuance of an order passed by a court in exercise of power conferred by 319 of the Code of Criminal Procedure be tried for the offence for which he is summoned? After the conclusion of the trial, wherein such an order of summoning was passed, is the question that falls for determination in this appeal. While answering the same, the two-judge bench in Shashikant held as follows. Provision cannot be interpreted to mean that since the trial in respect of a person who was before the court has concluded, with the result that newly added person cannot be tried together with the accused who was before the court when order under 3191 was passed, the order would become ineffective and inoperative, nullifying the opinion earlier formed by the court on the basis of evidence before it that the newly added person appears to have committed the offence, resulting in an order for his being brought before the court. The mandate of law of fresh trial is mandatory, where the mandate that newly added accused can be tried together with the accused is directory. The High Court has placed extensive reliance on factual matrix of Shashikant's case to draw parallels between the similarities in both cases. The summoning order in the former case, the trial has ended, whereas in this case it was passed after the trial has ended, is after the passing of judgment in session case number so-and-so. Therefore, this court, while dealing with Shashikant, interpreted the law based on the facts available therein, whereas the present case has a different context altogether. In this context, it is important to note that when Hardeep Singh's case was heard by the two-judge bench, this court took note of the findings in Shashikant's case supra. The two-judge bench observed that in Shashikant, during the pendency of trial of an accused, another person was summoned by the trial court under section 319 of the code. But by the time he could be brought before the court, the trial against the accused was over. It was held by this court that the words could be tried together with the accused in section 319 were merely directory, and if the trial against the other accused is over, such a person who was subsequently added as an accused could be tried after the conclusion of the trial of the main accused. Taking note of the above two-judge bench in Hardeep Singh, referred the matter to three-judge bench on the following question. When the power under subsection 1 of section 319 of the Code of Criminal Procedure of addition of the accused can be exercised by a court, whether application under 319 of the code is not maintainable unless cross-examination of the witness is complete. What is the test and what are the guidelines of exercising power under subsection 1 of section 319 of the code? Whether such power can be exercised only if the court is satisfied that the accused summoned in all likelihood would be convicted. Subsequently, this court in the aforesaid matter of Hardeep Singh laid down the scope and extent of the powers of the court in the criminal justice system to array any person as an accused during the course of trial as per 319. The questions which were formulated by the larger bench were, what is the stage at which power under 319 of the Code of Criminal Procedure can be exercised? Whether the word evidence used in section 319 of the Code of Criminal Procedure would only mean evidence tested by cross-examination, or the court can exercise the power under the said provision, even on the basis of statement made in the examination in chief. Whether the word evidence used in 3191 of the Code of Criminal Procedure has been used in a comprehensive sense and includes evidence collected during investigation, or the word evidence is limited to evidence recorded during trial. What is the nature of satisfaction required to invoke the power under 319 of the Code of Criminal Procedure to arraign the accused? Whether the power under 3191 of the Code can be exercised only if the court is satisfied that the accused summoned will in all likelihood be convicted? Does the power under 319 extend to persons not named in the FIR or named in the FIR but not charged? We note that the difference of formulation in the reference question and the final order of the Constitution bench with respect to question 1 makes a difference with regard to the present case. It is precisely the gap between the restricted formulation of question number 1 by the Constitution bench and question number 1 in the reference order of Hardeep Singh, which these unique facts fit in. The earlier question number 1 in the reference order was broader in comparison to reformulated question by the Constitution bench. It is this marginal area which is sub silento which needs to be referred to a larger bench. Again, in Hardeep Singh, the Constitution bench set out to answer the questions referred above. In this part, we are mostly concerned with the first question. The court, while assessing the ambit of the term trial, was concerned with the stage during which the power under 319 can be exercised, could be exercised. In this regard, it was held, since after the filing of the charge sheet, the court reaches the stage of inquiry, and as soon as the court files the charges, the trial commences, and therefore the power under 319 can be exercised at any time after the charge sheet is filed and before the pronouncement of judgment, except during the stage of section 2078 Code of Criminal Procedure, committal, etc., which is only a pre-trial stage intended to put the process into motion. This stage cannot be said to be a judicial step in the true sense, for it only requires an application of mind rather than a judicial application of mind. It was contended that the question of law here is unique to the present case, and the earlier judgment of Hardeep Singh did not have an opportunity to cast any light about the validity of the summoning orders pronounced after the passing of the judgment. They further argued that Hardeep Singh treats 309 in an isolated manner without taking into consideration the spirit and mandate of the court. To strengthen the aforesaid submission, the state further 465 was introduced to provide for a balanced mechanism under the criminal justice system to stop courts from getting into hyper-technicalities and committing serious violations. Court in Hardeep Singh has not considered the above principles or the issue that could possibly arise before the trial court while dealing with application under 319. The state therefore submitted that 319 should not be treated as an isolated island, should be given a pragmatic interpretation by keeping in view the entire mandate of the court to render complete justice. Needs to be determined whether trial is said to be fully concluded, even if the bifurcated trial in respect of absconding accused is still pending consideration. The appellant herein contended that observations made in Hardeep Singh cannot be diluted by a bench of this type. We have considered the averments made by the council on behalf of both the parties. We feel it would be appropriate to place the same for consideration before a larger bench. However, we are of the considered opinion that power under 319 being extraordinary in nature, the trial court should be cautious while summoning the accused to avoid complexities to ensure fair trial. We must remind ourselves that timely disposal of matters furthers the interest of justice. After perusing the relevant facts and circumstances, following substantial questions of law arise: whether the trial court has power under 319 of CRPC for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of conviction rendered on the same date before pronouncing the summoning order; whether the trial court has power under 319 for summoning additional accused when the trial in respect of certain other absconding accused is ongoing pending, having been bifurcated from the main trial. What are the guidelines that the competent court must follow while exercising power under 319? Then, my lord, matter should be placed before the Honorable Chief Justice. Then 5th September. The court said that it should go before.
Mr. Patwalia, therefore, once the judgment is reserved and before its pronouncement, as per Hardeep Singh, 319 can be applied. Now, that proposition is doubted in this case, right? Or what exactly is the point you want to?
The point is, after judgment is pronounced, according to me.
No, Hardeep Singh governs what situation?
Hardeep Singh says very clearly that Hardeep Singh interprets 319. The words of, let me just read 319 to your lordships first of all. Let me just read 319. Yes. According to me, my lord, my case is crystal clear, completely covered by what Hardeep Singh says, and this whole argument that application of mind time has to be seen is neither here nor there, because application of mind, it's the order of the court. Application of mind can be if the court has applied mind and deferred it and then ultimately decided it at a later stage. So just let me read 319. 319 is crystal clear. It was referred for interpretation, and Hardeep Singh is consistently followed by courts thereafter. There are judgments of this honorable court consistently following Hardeep Singh, and according to me, I am in no grey area. My case is completely covered by Hardeep Singh's view. But anyway, let me read.
For that, just tell us some basic facts in your case.
Yes.
Basic facts, then we will come to 319.
Let me just read 319 and then I'll go to the basic facts. Power, 319 says, power to proceed against other persons appearing to be guilty of offence, where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being the accused has committed any offence for which such person should be tried together with the accused, the court may proceed against such person for the offence which he appears to have committed. So the crucial words are, where in the course of any inquiry into or trial of an offence. That's the stage at which 319 can be used. Now, my lord, just kindly have one or two other sections, my lord. Just kindly see here itself, section 353.
What 3?
53.
353.
Dealing with judgment.
Yes, we have.
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of trial or at some subsequent time. So, when the matter is kept for judgment, it is after termination of trial and it can be pronounced immediately, or he can fix a date for pronouncement of judgment. But trial is over at that point of time. And what happens after judgment is pronounced is 362. Just this link will be complete. 362. The court will become functus officio. That is why your lordship says no review, no other application except clerical mistake, etc. Kindly have 362.
Yes.
Court not to alter judgment, save as provided by this court or any other law for the time being in force. No court, when it has signed its judgment or final order after disposing of the case, shall alter or review the same except to correct a clerical or arithmetical error. Your lordships have interpreted this to mean that after pronouncement, court is actually functus officio. I have made a note on that. I'll just be passing it over. Now, what is my case? But I have just made this pass on.
And even review is not permissible here.
In criminal law, yes. But I have just made, justified. Yes. Just kindly see this list of dates. I'll tell your lordships in my own words.
Basic facts we should know.
Yes. I'm going to give your lordship the facts, and in fact, there is a huge. This one. I am also a politician. What has happened in this case, I'll give your lordships a broad overview, and then I'll make out my case. I come from a political family in the state of Punjab. My father was an education minister in the earlier years. Of course, now he is no more. I actually contested elections for the last 2-3 decades. Earlier, I contested with the Congress. Then I became leader of opposition in the Aam Aadmi Party. When this whole episode happened, I was leader of opposition of the Aam Aadmi Party. I was exposing all these sand scams and other scams. This is my pleaded case. It's not something out of the pleadings. So I was exposing all these scams. Now what happens is that on 5th March 2015, and if your lordship will have page 1, I'll just quickly take your lordship through this list of dates, and then I just quickly, and then because depending on whether I had other arguments of malafide, etc. So if your lordship in this combination will examine only my first submission.
No, we are only considering the referred question.
All right.
Rest of all, I think it has to go back to.
Go back. So then I will give your lordships broadly the factual basis and in the setting in which the case arises, and then go to the referred question straight away. So after giving your lordship broadly the setting in which the case is arising and what actually happened, so that your lordship has an overview. So my lord, on 5th of March 2015, an FIR is lodged under the NDPS Act and under the Arms Act, etc. A total of at Police Station Sadar Jalalabad, District Fazilka, against 11 accused persons for heroin trade. Now there are total of 8 persons are arrested, including one Gurdev Singh of Bholanath constituency, ex-Sarpanch. I contest elections from this constituency, my lord, Bholanath. Sarpanch and ex-chairman market committee. Alleged recoveries are made from them. The petitioner is not named in the FIR, nor any overt or covert act is attributed to the petitioner. A special investigation team is constituted on 9th March 2015 through the IG Bathinda zone to supervise the investigation in the present case. That SIT is headed by the DIG Firozpur, SSP Fazilka and SP Fazilka as its members. According to me, the sole purpose of this SIT is to dig out some way to connect me with this crime. Now, the SIT gathers some phone call records of Gurdev Singh with Joga Singh and Manish Kumar. Joga Singh is my private security PSO and Manish Kumar is my PA. They are petitioners in the second petition, which is also before your lordships. That is 503.1. Gurdev Singh belongs to the constituency of Sukhpal Singh Khera, petitioner. On 10th March 2015, various news items appear in the media quoting the SIT members as saying that phone calls between the petitioner and Gurdev Singh and making derogatory remarks against the petitioner. Now on 4th May 2015, in view of the apprehension of being falsely implicated, Sukhpal Khera approaches the High Court by filing a criminal writ petition number 8999 of 2015. The prayer I have reproduced at page M on that petition. I said, transfer this investigation to CBI. Prayer 1. Prayer 2, I said, please protect me from arrest. Prayer 3, I said, in case I am to be arrested, give me 1 month's notice. and prayer 4 is another miscellaneous prayer that I had made. These were the 4 prayers. Now, my lord, what happens? On 6 September 2015, challan is filed against 9 persons, since 2 were declared proclaimed offenders and 1 of them was never apprehended. So the trial actually is against 11, but initial challan is only against 9 because 2 are declared proclaimed offenders. Now, thereafter, my lord, the investigating agency files an affidavit through the SSP Fazilka and writ petition number so and so, that is my writ petition. Now, this is very crucial, extremely crucial. On 6th July 2016, evidence of PW4, that is Ajmer Singh DSP and PW5 Jaspant Singh Inspector, was completed and a request by the prosecution for recalling on the same day is declined by the trial. So these 2 persons, Ajmer Singh and Jaswant Singh, who will ultimately then come back by a 311 application, they tender their evidence. In their evidence, they talk about me, but they do not say I am in any way connected with the crime. If need be, I'll show that to your lordship.
What do you mean by talk about you?
They say that yes, a question is put to them by the accused that this whole thing is politically motivated, that the accused are connected with Sukhpal Khera, and therefore they are being implicated falsely due to their connection with Sukhpal Khera by the then Deputy Chief Minister, who is also named, my lord, in that examination and cross-examination. Both of them do not implicate me in the crime at all, and I will read it if need be. Then I'll just complete the things. In May, this evidence takes place, my lord, in July 2016. In May then after this, there is a first supplementary charge sheet against one of the 2 absconding accused. He's detained, and therefore there is a supplementary charge sheet against him. Then the trial proceeds. By 31st July 2017, evidence of almost all other witnesses is over. Then if your lordship will just have the very last page of this list of dates. Just this, what I've given. Just kindly have the very last page. Page 26. Just see these dates, how the matter proceeds. So 6 September 2015, your lordship has that date or not? 6 September 2015 is the charge sheet against the 9 original persons. 18th October 2016 is the first supplementary charge sheet against that one of the absconding accused who is then caught. 28th May 2017 is the mining scam raised by me in the newspapers. One minister has to resign as a result of that. It becomes a huge scandal and a big issue in the state. In my rejoinder, I have placed those newspapers on the record. Now, my lord, it is then that on 20th July 2017, a second supplementary charge sheet is filed. The second supplementary charge sheet does not say anything, but is only filed for the purpose of placing on record some alleged call records of conversations between Gurdev Singh, his sister Charanjit Kaur, between, they say, me and my PS. That's the sole purpose of this second supplementary charge. After this second supplementary charge sheet is filed on 20th July, hot on heels, 31st July 2017, an application is filed for recalling of those 2 persons, PW4 and 5. The reason, those 2 police officers, the reason given in the application is their conversation with the accused and the call records have to be connected with the accused. That's the reason in the application for recall. Recall originally had been declined. I had read to your lordships. This recall application is allowed on 17th August 2017. On 14th September 2017, these 2 witnesses are re-examined. In their 2-3 pages of re-examination, they do not talk about any other accused. Their whole evidence is about linking me with the call records and Gurdev Singh. Now, that original statement turns curtain, and that's the whole purpose of their examination on this 14th September 2017. Then, my lord, on 21st September, they get one more person to say, I have got records from the telephone companies regarding those calls. He is asked to state that, have you got a 65B certificate? He says, I don't have a 65B certificate. In the evidence, in the written statement filed here, 2 undated 65B certificates are produced by the state, just pushed in. So I have an issue about that. Then, my lord, so after 14 September, 21st September, when this evidence, according to me, in commas, is procured against me through persons who had already testified and never blamed me, this application under 319 is filed on 21st September, and shortly it is allowed, and that is how I am made an accused in the trial. So one of my main...
What is the date on which the application is allowed?
Yes, the date on which the application is allowed is 31st October 2017.
What date? What date?
31st October 2017, the same day when the judgment is pronounced of conviction and sentence. So, my lord, according to him, Hardeep Singh also says what kind of evidence is required. And I had addressed at great length about the fact that, leave aside my first submission, this evidence is completely procured to fix me. And therefore, my lord, that is one of my main submissions. But in any case,
that is on the merits of the matter.
I just wanted to give your lordships a sort of a setting. And what do they say? How are they linking me? They say the same two officers who came. They say when these...
Again, we can't go into the merits of the matter.
I'm just giving your lordship,
as to whether...
in the next 5 minutes, I'm just going to give your lordship a little flavor of what I am facing. So that's all, and then I'll come to the questions. I have prepared.
We are called upon to answer some question, and we have to limit ourselves to that.
All.
This is my submission, my lord. In fact, it is only a reference. So, my lords are contemplating about the reference only. As far as the merits are concerned, my lord, that will be seen by.
That is what I have said.
Grateful, so grateful, so grateful.
Yes. Yes. Yes, Mr. Patwalia.
Flavor, so that our appetite.
So I just before lunch, my lord, I say. So
some food for thought.
So just 2 more lines and I finish this. 2 more, because his whole life, it's a life-changing situation for him. He was the leader of the opposition. He had to resign. He had to quit. His family is one of the premier families in the state. It's smeared on the basis. Now, what happens interestingly more, on the basis of this FIR now, there is a PMLA against me.
Just trying to define the meaning of premier family.
I was just telling my brother,
it's beyond
my learned brother, in Punjab, premier family would mean family like Mr. Patwalia.
I am grateful, my lord, but unfortunately, we are far away from politics, my lord. So, unfortunately, I should say. So, my lord, they are asked, what is the basis? They say, we actually interrogated them when they were arrested. So, what do you have to show? They show 5-6 loose pages of white paper. 5-6 loose pages. In cross they are put. Is this on the case diary format? They say no. Is this numbered? No. Did you produce it anywhere? No. So 7-8 loose white pages sheets of cross examination are the basis of all. So my lord, that is how, therefore, I am now, I then, after that I went in revision before the High Court. High Court rejected it, ultimately saying that High Court basically said 2 things. High Court relied on Shrikant, but the reference order itself put Shrikant out of the picture by saying Shrikant was on a totally different factual situation, because in Shrikant, the order under 319 was made admittedly during the pendency of the trial. But
Patwalia, if the trial court had allowed 319 application before the pronouncement of the judgment, perhaps you had no case according to...
On my first point. Yes.
No, merits we are not examining.
Yes.
You had no problem.
I would not have been able to argue that that Hardeep Singh's is violated. Yes, your lordship is right.
All right. Now, judgment was pronounced on the same day this 319 application was allowed.
Correct.
Before the pronouncement of the judgment, if 319 is allowed and then judgment is pronounced, what objection do you have?
Well, then I could have had an objection, because once the judgment, the trial was over earlier. The trial had been concluded, matter was kept for judgment, and therefore, by virtue of 353, therefore the court could not have done it.
Well, with my lord's permission, only one thing. Well, Hardeep Singh, which my friend is lying upon, says till pronouncement. I can read that. It is not conclusion of trial. Hardeep Singh says till pronouncement. So I'll refer to the paragraph. He's relying
I will also read it, Lord. Let my friend not be very anxious.
No, I'm just saying the Hardeep Singh you are relying upon, that says till.
So therefore, your lordship put me a question. It says inquiry or trial. According to me,
His contention appears.
We want to ask. Now, judgment is pronounced. Thereafter, 319 application is allowed. Is in a given case. Now, that has to be separately numbered, is it? What is the procedure there?
so I'll tell your lordship what happened.
What happens there?
Well, in the present case, it was already
So
separated.
same case can't continue. Same case can't continue.
But in the present case, it
We
was
are
already
before a
separated.
constitution
It was already separated. In the present case, it was already separated. 319, Malad, the Honorable High Court ordered the stay of the proceedings in the other case. So the learned trial court separated this application from the main case. So it was already separated and segregated, bifurcated from the trial.
Worse. But I will answer your lordship.
No, why we are asking? There is
I am
some,
answering
There is some
that
purpose, Patwale, please listen. You can answer it too.
Yeah, no difference.
Now, for example, supposing if an accused is absconding,
Correct.
trial can't stop. What happens?
I'll answer that. In this case, one accused is absconding.
What has happened?
Now, in this absconding,
Trial is separated.
no,
And it will be tried separately.
No. In this case, one accused is absconding. On the date when my application was allowed, there was no trial pending regarding him because no charge sheet had been filed in his case. It was still at the stage of investigation. So therefore, that's crucial. It's a very pertinent question here. There were 9 accused to put on trial initially. 2 were absconding. One of the 2 was then arrested. For him, charge sheet was filed, first supplementary charge sheet. For the second absconding accused, on the date when my application was allowed, there was no charge sheet. There was no trial pending. So therefore, what the court had to do, when the court allows my application under 319, the court gives a further direction to the police to file a supplementary charge sheet against me. That direction, the High Court, while dismissing my revision, quashes that direction, saying such a direction could not have been given. So therefore,
Charge sheet cannot be filed against you, then how can?
Yes, it cannot.
so there can be no direction to file a charge sheet, is the view taken by the High Court.
That would lead to an anomalous situation.
No, that's the correct the position in law. High Court.
No. If the High Court has quashed the direction to file a charge sheet,
Correct.
and also on the other hand, granted permission to conduct a trial against you. So can there be a trial without a charge sheet?
Yes, that's precisely the point. Therefore, this 319, Mr. Gai, please allow me to finish.
It is all right. I'm just putting my facts forth.
We will hear you, sir.
Oh, so great. So grateful. So
We will
great.
hear you, sir.
I'm just putting the facts right. That is all.
We will hear you.
I don't give any wrong.
No, I am not saying that at all. I'm not saying, I'm adding to what you said.
No intention
Mr.
of
Patwali, I'm just adding to your facts. I can change my.
2 o'clock.
Well, it is always better. Well, it is always better to argue not before an empty stomach, honorable judges.
Decorum. So, my lord, therefore, the answer to your lordship's question. Therefore, it is even
to learn decorum from Mr. Patwali.
Therefore, it is even more important that this 319 should be allowed when the trial is still pending. Because if you allow it after trial is concluded, you cannot give a mandate to the police to necessarily file a charge sheet. Therefore, it will reach an.
We consider it true.
Yes.
Tough case, it becomes a tough case.
Take into Nagamati also. Supposing if you direct him to file a charge sheet itself without an investigation.
Absolutely.
is it permissible? You are presupposing, the judge presupposes that he is an accused.
So therefore,
That
my
is why
lord,
it requires an investigation, if I am right, assuming it to be so under
let me
170.
answer your lordship.
With respect, my lord.
Let me answer your lordship's question. There-
Subsection 4.
Therefore, my lord,
Yes, sir.
319 necessarily has to be allowed when there is some trial pending. Because it cannot be allowed in a situation when there is no trial pending. In my case, on the date when my 319 was allowed, there was zero trial pending. I could have imagined if there was a trial pending against the absconding accused, still there would have been a trial pending. Therefore, my lord, the point is.
No, the trial insofar as a absconding accused is still pending in your case.
It's not, it was on that day not pending. Subsequently, I am told, a charge sheet was filed in 2019 against that absconding accused. So in 2019, it is a fresh trial with a separate number of 2019. My application has been allowed in an earlier trial, which was not pending on that day. Therefore, the question was of filing a direction to file a supplementary charge sheet.
It would be a split up trial.
All right, we will come back.
Yes, yes.
Very interesting question.
Correct, grateful.